The Center for Continuing Education presents Elimination of Bias in the Legal Profession. In this one-hour program, attorney Steven Nielsen offers a fresh look at bias in the legal profession. Does a mere study and rote following of state bar rules address the larger issues? Mr. Nielsen notes that, in general, the reasons for our bias problems have been a taboo subject. He offers a candid assessment of the nature of bias and discrimination and how they have evolved in society and throughout history. He poses the question, is it realistic to expect a complete elimination of bias in the legal profession, or does it make more sense to understand the forces at work in human nature and to implement common-sense steps to reduce bias and discrimination in the law office environment? Steven A. Nielsen is a partner in Allman & Nielsen, based in Larkspur, California. Mr. Nielsen is a U.S. registered patent attorney with many years of experience in obtaining patents and achieving favorable results in federal court in the field of patent litigation. He is the past chair of the Intellectual Property Section of the Marin County Bar Association. Mr. Nielsen received his J.D. in 1987 from Bolt Hall School of Law, University of California at Berkeley, and also holds a B.A. in Computer Science.
Good afternoon. Thank you for coming today. I hope to put on an interesting seminar, and if anyone has any questions at any time, feel free to raise your hand and I will call upon you and we can discuss whatever issues you have within reason. Today's presentation was originally entitled The Elimination of Bias in the Legal Profession. After I worked on my presentation for some time and restudied the various scientific studies that I've researched, I changed the name to The Reduction of Bias in the Legal Profession, because we're not going to eliminate bias today, maybe not in our lifetime. Hopefully during our lifetime we can reduce bias in the legal profession. So I don't mean to be pessimistic, I just want to be realistic, and hence the name of the presentation changed to The Reduction of Bias. My name is Steve Nielsen. I'm a registered patent attorney. I work out of Marin County, California. I'm with the law firm of Allman & Nielsen, and we're at 100 Larkspur Landing Circle, Suite 212, Larkspur, California. And if you have any questions or you want to look at my website, I'm at nielsenpatents.com, NIELSEN I'm the past chair of the Marin County Intellectual Property Association, and I've written many patents for many inventors in different fields, mostly mechanical and electrical, and I do litigate patent cases. In preparing for this, I was thinking about what is bias, what is discrimination, what's diversity, and one can go on and on about where one wants to go with the subject. So to have a guidepost, I copied down the general rule from our State Bar of California. I believe most states have similar rules. And I wanted to take some time and go through the actual rule and the language therein so we can stay on relevant subject matter when we deal with a subject that is potentially volatile or many people can feel uncomfortable discussing. One of my goals is to alleviate some of that discomfort and talk about dispassionate science and look at things from a distant or objective point of view. In California, there is something called prohibited discriminatory conduct in a law practice. The statute first defines a law practice, pretty broad definition. It pertains to solo practices, large law firms, small law firms, anything dealing with the the practice of law. The next condition is knowingly permit to take a corrective action when an attorney or member knows that there's a discriminatory policy or practice. This verbiage should be amended to read knows of a prohibited discriminatory policy, because as we'll get into later, pure discrimination in and of itself is not necessarily a bad thing, but we'll deal with that later in the presentation. There's a great definition here in number 3 of unlawful or unlawfully, engaging in an unlawful discrimination in the employment or offering of goods or services to the public. This part of the guideline or rule I think is well written, because it talks about what's an unlawful discrimination, and also what's interesting here, one of the themes of this presentation talks about it's unlawful to have an unlawful discrimination in employment or in the offering of goods and services to the public. That gets very broad, offering of goods and services, and it goes beyond the practice of law. And then in Part B, talk about the management or operation of a law practice. You're not allowed to knowingly or unlawfully discriminate, good term, unlawfully discriminate, or knowingly permit unlawful discrimination on the basis of race, national origin, sex, sexual orientation, religion, age, or disability. So we're going to call these the protected classes. And one of my themes here is to suggest that while these protected classes, maybe members of them are quickly discernible, are these classes somewhat arbitrary, or are these groups of people somewhat arbitrary, or an arbitrary grouping of people? A lot of people aren't going to like that idea, because let's take race for example. There's been a great deal of unfortunate history of people of different races being unlawfully discriminated against. But I want you to keep an open mind to the issue of, do we want to limit our analysis to just these protected classes or these protected groupings or groups of people? Part B1 here talks about hiring, promoting, discharging, or otherwise determining the conditions of employment of any person. And I've highlighted determining the conditions of employment, and that is very broad as well. And that can get into things of requiring certain members of a law firm to work on diversity programs where they're not going to bill as many hours. And so you're determining the condition of their employment based upon perhaps their membership of a protected class or a protected group. And one of the questions that I've read in studying for this is, if you make certain people in a law firm spend their time in diversity programs or any program where they aren't going to bill hours, are you helping them, or are you doing something that's in their long-term detriment? We'll talk about that later as well. And then Part 2 is interesting, could be better thought out, accepting or terminating representation of any client. So we talk about terminating representation. The question I have here is, if you accept someone for as a client, if you've met them, you may be able to figure out what class of people they're in, or what group they're in, at least in these enumerated protected classes. So how would you terminate them based upon an unlawful discrimination? I mean, did something change? It may seem like a trivial question, but it just kind of raises a red flag in my mind. So let's again think about this general rule. Unlawful discrimination is not allowed, and discrimination or the treatment includes determining the conditions of employment. And for purposes of California, we have the protected bases of what I just mentioned before. So that's the general rule, and we'd have a very boring presentation if I stayed just on this general rule and went through some rote platitudes about what to do, what you can't do, because deep down we all know what that is. We've all heard that before. But what we're going to get into here is, why do we find ourselves in a position to need to do this, to reduce the elimination of bias, or the state of California has this platitude of eliminating bias in the practice of law. So the proposed big picture view, which I'm going to pursue today, and I welcome all of you to think about this and question everything, because whatever we're doing isn't working. So we don't have to take anything as sacred in this field, and I think we need a lot of thought and a lot of work in this, because it's a serious problem, and from what I can tell, there are no clear-cut answers or clear-cut solutions. So what I'm proposing is a different way to look at this, stepping back and addressing the issue of why people favor members of their own group over members of another group. That's the big premise here. Can we address the issue of why members of one group favor members of another group? And what are groupings of people? Can we acknowledge this premise? Do we dare look at the social work or the work of social psychologists and their peer-reviewed studies on the issue of what we call group dynamics, people being in a group or two competing groups? Okay. And then the question is, are studies in group theory relevant when groups are defined by protected classifications such as race, national origin, sex, sexual orientation, religion, age, or disability? That's a big starting block, and I know I've repeated that, but that's something that I question. I think it's appropriate to study group theory even when the relevant groups for purposes of the state of California are the protected classes. Now, there's certainly room for reasonable minds to differ. There's going to be some differences between the protected groups or classifications versus random groups of people, but I think studying what happens amongst random groups of people is very telling as to why we have the picture for which we're here today. The other question I want to address is the reduction of bias in the enlightened self-interest of members of the legal profession. In other words, is it in our best interest to address this and deal with this, irrespective of what the law may require? And this may be something you want to think about on your own. My quick answer is, if you study The Invisible Hand by our great founding fathers, the idea is that if you hire the best person for the job, you'll make the most money, and it doesn't matter if they're a member of a certain group. So it is in our enlightened self-interest to think about the underlying issues and reduce our level of bias or unlawful discrimination. And then, should we be mindful of factors beyond the protected classifications to address issues of improper bias and improper discrimination? So in other words, we have our enumerated protected classes. Should we think about other subclasses or other groups of people in thinking about eliminating our bias or preconceived notions? And the short answer here is yes, for reasons that we'll get into. And should we discuss real-world examples of successful bias diffusion? The term bias diffusion, I sort of made that up, but what it means is, let's talk about some real examples that I've seen or heard about where things happen either in a mediation, in a law firm setting, in a court setting, where someone acknowledged a potential for unlawful discrimination or improper bias and diffused it, addressed it, and moved on, so that people could go on with their day and hopefully learn to reduce the problem in general. So let's have some fun with words here. What is bias? I have a picture of dog food and a picture of an apple. Now, for me, I have a slight inclination to be more attracted to the apple than the dog food. It's a good place to start. I'm sure people can understand that I'm not discriminating, although I've never tried dog food, but I've eaten a number of apples. But I think I know enough about dog food to say, well, maybe I'm biased maybe not being discriminatory in that I'm judging something that I think, a subject that I think I know about, and that I have some knowledge of these two things, and I'm not categorizing all dog food as the same or all apples as the same. What does bias mean in the area of mechanical engineering? And here's a patent that I did as part of the Steadicam series of cameras, and we have a mechanical arm here used to help an ultrasonic machine on a patient. The mechanical arm takes the weight of the machine off the operator's arm, so they live longer and don't hurt their arm. So we have a mechanical arm here displayed, and we have a spring that may urge or push the arm member in a certain direction. So if you want to go up, there's a spring tension sort of urging this up, so it takes very little movement to push it up, or in a natural position, it just moves in a certain direction to ease your movement in that direction. So this is called mechanical bias. And I just wish that we could deal with group bias as mechanically and impassionately as we can with this mechanical arm. Because if we have a problem with this mechanical arm, we take it apart, we look at the spring, we measure the angles or the vectors, we make adjustments, and boom, off we go. The analogy here is that the term bias means a certain persuasion toward one side or one direction or another. Gets us into the theory of group bias, which can be defined as an attraction or lean toward members of one's own perceived group. So if I perceive that I belong to a certain group, I'll have an attraction or lean favorably toward members of my perceived group. Conversely, I may have a distrust for members of another group. This is the basis of group theory studied by many social psychologists. And group theory leads to stereotypes, for one thinks that members of another group are all the same, or that traits seen in one member of another group permeate the entire group. For example, if I see that a member of another group wears t-shirts with black stripes, I'm going to think, gee, I think maybe all the members of that group wear t-shirts with black stripes. And I hope we can study this in a factual and unemotional matter, such as the spring bias issue of the mechanical arm, but we'll see. Here is something that I've been learning about since my days of college. The professor there was actually a lawyer, a really good law department in my undergrad, talked about what is discrimination, and is discrimination in and of itself a bad characteristic. And it's important to dissect these words. For example, if I go to Trader Joe's, I could be presented with what's known as the $2 chuck or the $3 bottle of wine. Or I can walk over to Bevmo and they have Free Mark Abbey wine, considerably more expense. I've tried the Free Mark Abbey wine, I like it. I've heard things about the Trader Joe's $2 chuck, it's about $3 now. I've asked about it. And I'm going to venture to say I have somewhat discriminating taste when it comes to alcohol, and I prefer the Free Mark Abbey, and I'm going to buy the Free Mark Abbey, and I'm not going to buy the Trader Joe wine. Now, is that an unlawful discrimination? No. Is it a smart thing? I would think so. Is it discrimination? Yes. So we need to be careful with our words. In the future, it would behoove you to not say, well, that's discrimination. You might say, well, that's a good discrimination, or that's an unlawful discrimination, or that's an inappropriate discrimination. But if you just say that's a discrimination when you see some social injustice, you're kind of showing a lack of thought and a lack of clarity, and it shows you really haven't studied the issue. Let's look at the dictionary. Discriminating, a verb. It means, in the adjective, it means differentiating, analytical. Analytical, discriminating, analytical. Did you expect to see that in the dictionary? Probably not. But it's important to keep that in mind. It also means noting differences or distinctions with nicety. discerning, a discriminating interpreter of events. These are positive attributes. Having excellent taste or judgment, a discriminating in interior design. Also means differential as a tariff. That sort of has a bad connotation, meaning we're going to charge more money as a tax for goods that come in or come out of the country. Also means possessing distinctive features capable of being differentiated. So if you look at the pure dictionary definition, discriminating doesn't have bad connotations. So it's important that we talk about the basis of discrimination if we're really going to get anywhere on this subject. And just to hammer the point home on discriminating taste, I've cut and pasted a picture of sage roasted buttermilk squash and cider soup with the recipe. So think of this nice cup of soup, and you have discriminating tastes, and this is preferable, this is desirable, and perhaps the word discrimination should not be so feared. Another issue getting closer to the bigger issues is we have tequila, and there's silver tequila and there's añejo tequila, and should we judge tequila by its age or price? The añejo tequila is a bit older, has a gold color, the silver has a clear color, and the bottom line here is that not all tequila is the same. My preference is for the añejo tequila, but I opened my eyes, and my favorite tequila is the silver tequila by Grand Patron. It's $200 a bottle, so maybe the price has something to do with it, but not all silver is the same, and not all of the gold tequila is the same. Other hand, keep a very open mind. Costco sells excellent añejo tequila, and as I tell my daughters, if Costco doesn't have it, we don't need it. And there's some excellent tequila añejo at Costco. So again, it's important to study things and let go of our preconceived notions if we're going to make a proper judgment. Nelson Mandela, wonderful man. There's some great quotes by him. This one I like. I learned that courage was not the absence of fear, but the triumph over it. The brave man is not he who does not feel afraid, but he who conquers that fear. Makes sense. I don't know if he was the first person to say that, but on my notes here I write down, makes sense to me, and I like that phrase. The next phrase, though, that I heard, I want to dig into. It says, no one is born hating another person because of the color of his skin, or his background, or his religion. People must learn to hate, and if they can learn to hate, they can be taught to love, for love comes more naturally to the human heart than its opposite. Do we learn to hate? I don't know. Just before this lecture, I was talking to a learned attorney of the building here, and he asked, am I going to get into the issue of bigotry? And my response was, no, I'm not, because I think it exceeds the scope of what we want to do today. And it gets into a bag of worms that we don't need to address for the goal of reducing bias. But when I thought about that between then and now, I thought, well, if we consider bigotry, this quote by Nelson Mandela does make sense, because I think that bigotry is something that's learned. And I can stop there. But the other question is, do we have a dislike for groups in general that's taught, or is it just sort of part of our innate human nature? So I think if one considers bigotry, I think Nelson Mandela is right on the money here. If we read this to mean, do we have to learn to hate people of other groups, even though they may be arbitrary groups? I think that's in our innate nature, and it's not something that we learn. People may not like to hear that, but that's my opinion based on the studies that I've done. I know it's not optimistic, but that's something we're going to explore. I'd like to talk about how did we evolve. And I have a picture of some painted Neanderthal people of 100,000 years ago, probably Homo sapiens. And the idea was, in group theory, if we're out and about and we see someone outside of our group we want to quickly figure out, are they a friend or are they a foe? Now, the group identification could be just someone we know or not know. Everyone around could look pretty much the same. So it's not a prejudice or predetermination based on any notable class. It's just whether you know them or not. Are they a friend or a foe? If you don't know them, you think, oh, they're in a different group. And perhaps we evolved to be suspicious of people in a different group because there could be an element of danger. People who didn't pass those traits on, people who didn't feel that way may not have survived, and people who felt that way maybe survived and passed those traits on. So we want to think about, is quick identification in a group something that we evolved to have to survive 100,000 years ago when things were different? Was there a need for a quick decision based on sort of a flight or fight theory? And also, are we to ignore Darwin on this theory that perhaps we all evolved to have certain traits that would help us survive and that we would pass on to others? There are advantages to being in a group, and this is important to think about with respect to the past slide of people were in groups. We evolved to be in groups. There were efficiencies in hunting, gathering, and child rearing. There were efficiencies in companionship, emotional support. Wasn't difficult to survive alone in the Stone Age. So we did evolve to becoming social animals. And as many, I forgot who said this first, no person is an island. So we want to think about groups themselves aren't necessarily bad. I think more than ever we need to be interconnected. It's nice to be in a group, and I think we evolved to be in groups. So that helps with the relevance of why we have groups and perhaps how we evolved to have certain preferences or certain behaviors, whether we're in a group or we're out of a group. Now let's get down to some more scientific study here. There's a famous author, Henri Tajfel. He was a Holocaust survivor and a social psychologist interested in the behavior of people placed in groups. His personal history, I probably said enough, was more horrific than most of us could ever imagine. But he had the presence of mind to go through something horrific, lose many family members, and then when it was all over, go to England and study why things happened. He could let it go, he could be dispassionate, figure out what can we learn about group theory that would cause such egregious things to happen and arguably have never stopped happening. What he did, one of his experiments, he attempted to find a threshold of relevant human attributes that would lead to group prejudice. So in other words, he would take subjects and he would place them in different groups, and he would start out saying, okay, we're going to have people with blonde hair in one group, red hair in another group. And he'd do things and the groups would not like each other. Okay, let's go to something more trivial. Someone who grew up on this part of the town, someone who grew up in the other part of the town. Same result. So finally he got down to the point where he got people together and he flipped coins. And so, okay, heads, you're this group, tails, you're in this group. So that's it. It was just a coin toss. Put people in different groups, and then he would have the groups do different events together, have meetings, have competitions, and he found that the group problems arose even when the groups were divided by a coin toss. And that's disheartening. And this study has been well cited by a lot of people over the last 60 years. And what it means to me and a lot of more learned people than I am is that if you have groups, you're going to have group identities. And unfortunately, the natural human tendency, maybe going back to our DNA, is that we're going to be suspicious of people in other groups. And this is disheartening because these are random groups, and where you really physically can't tell who's in one group or another. But then when you go to the protected classes, the protected groups, where you can, the problem gets even worse. So it's just a fact of the studies, and it's something we need to think about and deal with. And it's not the cheery message you may have wanted to hear today, but it just appears to be the current studies of the human condition. But there are things we can talk about, and there have been things studied to help with this issue, but I would be less than truthful if I didn't disclose this study and what other social psychologists have read into it and what it means. So to me, it's very profound. We take a bunch of people, flip coins, put them in two different groups, do competitions, and these groups hate each other over the long run. Anyway, I suggest you would look this up, Henri Tajfel, Tajfel, and part of the supplemental materials in the video, I do have some articles written by scholars on this very subject. So that's profound. And then what he also found, which I think other scientists have found, the groups exhibit sort of an us versus them mentality. So the issue here that this raises is this relevant today, and being mindful of all human attributes, and that if we can have groups defined by anything, random groups, do we need to be careful to not be biased against anyone in any group? It's just a thought that we'll talk about later. Now here's one of my favorite social experiments, next to the one at Stanford where people got shocked until they stopped, but that's another subject. In about 1954, there was a social psychologist, Munsir Sherif, S-H-E-R-I-F. He took 22 12-year-old boys to Roberts Cave State Park in Oklahoma. And these boys, I'll call them boys, were randomly selected for each team. They didn't know each other, but they're pretty much the same religion, same race, same socioeconomic status. And they randomly put them into two teams. And at first, neither team knew of the other team. So the first group of 11 boys, they do things together, have fun together, and then later they were told about another group. They never met the group, but they were told about it. And they would talk about this, and they found that each group became suspicious of the other group without even meeting one another. And then what happened is they had competitions, hopefully friendly competitions, fun things to do, foot races, things like that, and hostilities arose. And what happened then is that one team would destroy the mascot of the other team. The teams started out with verbal fights, they later got into physical fights, and then they tried to diffuse this and have cooperative meetings, and the hostilities still ensued. Now, social psychologists have said this was not a perfect study. It's not a great sampling of people, but I think if we know 12-year-old boys and humans, we can kind of see this happening, and to hear the whole story of how acrimonious the events were between the two groups. It's a bit humorous, but it's understandable. But yet it does exemplify group theory and the group attributes we discussed earlier, how people in one group distrust members of another group, and how we're very suspicious of other groups. And also kind of bolsters the theory that we are social animals, and we have an interest in groups, and groups are important. This other subject may get beyond the bounds of the subject here, but is group theory supported by current events? There's some really good work by Professor Mark Levy of Duke University. He does a really good video, Understanding the Mysteries of Human Behavior, offered by the Great Courses. I've seen all 24 hours of it. It's really good. He does a whole hour on group theory, and he put this theory together of that over the last 100 years we've had over 200 million people killed over political events such as war or genocide. Now that's a staggering number, and we all know it's true. It's not something that's been made up. Involves World War I, World War II, and more recently look what's happening in the Ukraine. Look at the ethnic cleansing in Croatia and Serbia, or former Yugoslavia. It's disheartening, and it's a good perspective because here we are in a legal environment or an office environment, and things are pretty sedate. Sure, somebody may slight someone, But we aren't having this mass genocide in our office environment. But the state of humanity, we can't ignore it. And there have been 200 million deaths on political events, arguably based upon groups fighting one another. And so isn't this relevant for our study of group theory? We seem to have never-ending warfare between groups of people. Now, admittedly, some of the warfare pertains to the ownership of property, but again, it does get down to often gets down to group hatred. So, are we surprised to find some in-group versus out-of-group conflict in our legal profession? We want to think things are a bit more sedate in our nice law offices, but if we look at the human condition, it's no wonder that we do have problems. Now, groups are traits to consider in the reduction of bias in the legal profession. Here's just a theory that I offer. Since traditional group behavior occurs when group members are selected by a flip of the coin, which we talked about in the Henri Tajfel, do we need to be sensitive to everyone every day? I think so. It exceeds the rules of professional conduct. And here in my notes, I have to disclose that no, I don't drive a Prius, and I'm not a real touchy-feely guy. But I think the logical conclusion, if you study the group theory and the fact that any classification of people can form a group and you have group problems, if we're really going to follow the spirit of the rules of professional conduct on unlawful or improper discrimination, and look at the very broad definition of Part 3 of the Rules of Professional Conduct regarding employment or conditions of employment, or what's unlawful being determined by reference to applicable state or federal statutes or decisions, making unlawful discrimination, etc. That gets very broad, and our group theory gets very broad. So I'm offering the idea that we need to be sensitive to everyone, every day, irrespective of the group they're in or what traits that group may have. It sounds a little touchy-feely, and it's not where I wanted to go when I started writing this paper, but it just seems to be the logical conclusion. Also, it doesn't cost a whole lot to have some sensitivity toward the needs of others, or to be thoughtful and considerate. No one goes to bed at night thinking, gee, I spent too much time being considerate of someone else. Also, it's more profitable to be considerate of others and to think before we speak or act. Unfortunately, our words can be very powerful. So the protected classes are just the start. While the protected classes have faced a disproportionate share of unjust discrimination and hardship, as thinking individuals, do we want to limit our concerns and actions just to the protected classes? So do we consider possible attributes of people who belong to protected classes? So here we go into what I think is the logical conclusion. If you study theories of diversity and movements to have more diversity in office work or the legal profession, we get into sort of subtraits of different protected classes, or purported subtraits. I don't believe in all stereotypes and everything's the same. So if we consider the possible attributes of people who belong to a protected class, and being careful. For example, wealth. Let's just presume that maybe certain groups have more perceived wealth than others at this point in history. Do we want to talk about, when you're with people, certain things pertaining to wealth, or are you going to put off people who don't have wealth? We're going to talk about this more later. So perhaps broad definitions of diversity are helpful in defining the scope of our anti-bias efforts. Where can we remove the bias spring? So what I did is I cut and pasted from some very liberal website about diversity, about the different definitions of diversity or different attributes that one may want to consider in having a diverse workplace. Now, I'll read this list to you. It's also on the slide behind me. But the question I present is that at some point, have you studied a person enough that you don't have to worry about attributes or diversity, that you can judge the person with knowledge to make whatever decision you need to make with respect to that person. So in other words, we have these great platitudes here of diversity going into something called thinking style, which I never thought of until I wrote this paper here. And my question is, if you get to know someone so well that you know their thinking style, and you make a determination about that, say based on thinking style, is that an unlawful or improper discrimination or discernment? I don't know, but I question that. And I wonder, at some point, is there a line where one judges on, makes an improper judgment on certain attributes versus a proper judgment on certain learned qualities of a person before making a decision? So I think some of these diversity theories, maybe they go too far, maybe they don't acknowledge that, yes, it's okay to hire or fire someone based upon their performance. But I don't want to go too far into that. So here are the broad diversity basis that are offered. They include our protected classes and include communication style, culture, family status, language management style, physical appearance, thinking style, speed of learning, and comprehension. I'm not sure what to do with all of this, but I just put it out there as something to think about, as what's a proper discernment, what's an improper discernment. But it is relevant to think about, if we're going to be sensitive toward others and reduce our bias, our improper bias or improper discrimination toward others, maybe these are things to consider and to acknowledge and to think about, and withhold judgment until we know more about the person. So maybe we see someone has an interesting speed of learning or comprehension or thinking style or management style, and we don't stop there. We withhold judgment until we learn more. Maybe that's a good way to read this list of diversity attributes. So I'm going to, I think most people would agree, we're still allowed to judge or discern, but with knowledge of the individual. Are we still allowed to hire the best qualified? Are we still allowed to think about our enlightened self-interest? Hire those who are best qualified and will make the most money, as I mentioned before. And the reference I was thinking about before was, we have Adam Smith and his invisible hand theory. It does work sometimes. Now, when I went to school, I took a lot of economic classes, and we all seem to think, oh yeah, the free market economy is the best. But there are times when it doesn't work, when you don't have perfect information, and you have some irrational behavior. And my one quick story on that is, I talk about the Adam Smith invisible hand theory does work sometimes. And I'm going to give my one quick story here about, I was with my family a couple of years ago, and we were in Oakland, and we came out of the Oakland airport. We were hungry and miserable and tired. My daughters were, I don't know, 9 years old and cranky. And we went to Oakland, went to this Mexican restaurant, and we were the only people there with blonde hair. And we sat down, we were hungry, and we weren't served. And this is the first time this ever happened in my life. And my wife and I, we were angry, and then we were kind of amused, thinking, they don't want our money, fine, we'll go somewhere else. And sure enough, we got served. So for me, it was more of a learning experience, more of an inconvenience. And Adam Smith's invisible hand theory worked because I spent my money somewhere else. But if I went to the next place and I wasn't served, that'd be a real problem for me. And I know it's been a problem for others, and this invisible hand theory just wouldn't work. So we need to think about that as well. So how do we reduce bias? There are studies on this. There's no quick, easy answer on it, but there are ways to do and don't do it as well. Now, I'm sure we've been to these lectures before where they talk about law firms having various programs and things. Those don't always work. One of the ways to reduce group bias or group dynamics is to unite the groups via a common goal or common identity. How can we do this in the legal profession? Well, we could instill sort of law firm team building exercises of people identify with the law firm in general. In my experience, the law firm softball team was a big fail because it perhaps correctly discriminates against people who aren't very athletic or coordinated, and so you don't get to play on the softball team. You just get to watch, you feel slighted, and it's not a fun experience. So I would suggest that the softball teams are not a good idea. But let's think about the law firm team building exercises and creating a common identity. In very large law firms, you might have a dichotomy between the litigators and the transactional attorneys. And seldom do the two meet or go to the same team meetings. Perhaps you could do some team building where they do things together, and you could build up a inner law firm identity. But here is what's troublesome, is the social scientists find that if you unite two groups, let's say litigators and transactional attorneys in a law firm, yeah, you can unite them. But inevitably what's happened is that they're going to form a good group and they're going to become suspicious of the next group. In this cycle, it's hard to stop. And I won't draw too much analogy to Mideast politics, but that's what the learned writings tend to show. You unite a group and they become prejudiced or biased or suspicious of the next group. So we need to figure out how to deal with that. It's the human condition. It's the difficult cycle to stop. But it's something we have to acknowledge, and when you read the literature, the social scientists, they seem to agree on this. And this gets back to our DNA and our group theory and the earlier studies we discussed, is that you can unite a group, but they end up disliking, being distrustful of the next group. It'd be great if it could be just one world group and have world peace, but I just can't say that. I don't think it's going to happen. But that would be nice. But that seems to explain a lot of things as to why we're in such bad shape as we are with respect to group theory and groups not getting along well. How else can we reduce bias? Direct meetings between groups may not work well. If we just take one warring faction against another warring faction, put them together in a room, it's not going to work well. And this bears out, if you remember Henry Kissinger in his shuttle diplomacy in the Mideast, he didn't put the two parties together. He would talk with one, talk with the other, and then eventually they did talk directly at Camp David, but it took a lot of work to get them there. A more relevant example, if we just took direct contractor groups, it's not going to work well. That's what the studies show. But if you can do a meeting between the groups, but it has to be controlled. The members of the group must feel equal. So they have to be on equal footing, feel equally honored, have the same seating, same conditions. And this is a good transition to the issue of what individuals can do to reduce bias. Because I think, as someone before this lecture began, isn't it all about getting to know someone? And I'll say, this is the same conversation we had about bigotry, is that once you get to know someone, you don't notice their membership in a particular group. Not to degrade the group, but after a while, you don't see them as having any physical attribute, and you see them as an individual. So how can we, at an individual level, how can we make everyone feel equal? I suggest that we be very mindful of the subject matter of your small talk. And this is where I get into the fishing story with the judge. Years ago, a young lady was in a settlement conference between an older plaintiff lawyer, a judge, and herself, and the plaintiff lawyer talked to the judge about fishing. And this judge up in Napa, California, was very artful. He said, "I appreciate you noticing my fishing pictures, but we're not going to talk about fishing because that's going to unfairly alienate our female counsel here. So let's just stick to the case." And this was years ago, and I thought that was a really gentle way to sort of diffuse it and to be sensitive and mindful of attributes of a subgroup, females who may not fish. Turns out this gal was a good fisherman, but the judge presumes she doesn't fish. So let's not talk about fishing, because when you bring this group together, this person who may not know about fishing isn't going to feel equal. So this judge was very clever, and this was a very successful diffusion story. That's helpful for us to know. So how can we make everyone feel equal? We want to be mindful and versus vicious small talk with a twist of one-upsmanship. And speaking with others, our hobbies, possessions, and first world problems may be used to put down others. And my favorite example that I made up myself is, I don't know if anybody had the pleasure of getting the new $100 bills. Well, they stick together. And so I like to make first world jokes. I talk about, oh, my new $100 bills stick together in my billfold. Well, it's fun, but it could alienate people who don't have $100 bills in their pocket. And I'm using this as an example of being mindful of our small talk so that we don't alienate or make people feel unequal. Because again, to get back to the prior slides, to help with the reduction of bias, we want to have meetings where people feel equal. Another thing we could not talk about is my school has excellent diversity, having both violinists and cellists. Now this is offensive on various levels in that you talk about your child going to private school, you're going to alienate those who don't live around private schools. I grew up in Placerville, and there weren't any private schools. There were just public schools. So if I would have heard this, I would have feel less than equal as well. So to get back to the judge's fishing story, it's often difficult to find small talk that works for all. Perhaps current events are good, but political discussions aren't helpful for obvious reasons. We're all going to have learned differences of opinion. I think sports are somewhat dangerous, even amongst men, because personally I don't watch a lot of football or sports. It doesn't interest me, but a lot of people try to bond by talking about sports, because it's a fairly good segue amongst many men. I would suggest that we just stick to business and avoid small talk in general, and to bridge the gap, it's nice to talk to somebody one-on-one and get to know them, which leads me to my skilled mediator example. Before this presentation, the idea of Dale Carnegie's book, How to Win Friends and Influence People, came up. We're talking about the you point of view, and a learned professor here in the building talked about how when he was in college, he was required to read this book. And I asked him, well, were you harmed by it? He said, no, it was a good book. And I mentioned that, yeah, it's still there. I bought a copy for my daughters, and you can get it now 70 years later. He didn't read it 70 years ago, but the book's been in print for 70 years. And it's a great book, and some people who trivialize it say, well, isn't it manipulation? I don't read the book as manipulation. I read it as putting yourself in the shoes of others and being thoughtful and mindful and thinking before you speak. So a lot of good mediators and successful people think about the you point of view, and they talk to somebody as an individual, and they try to find something in common. There's some great mediators over at JAMS in San Francisco who are just very artful and subtle and skillful at this. Even though I know what they're doing, it's still a pleasure to watch. And they'll find something that you may have in common, and they'll talk about that. And they do a pretty adequate job of building some bond or some trust so they can go on and do their business. I would suggest that we all do that. If you find a genuine common interest or common point of view or just common observation. So in speaking to others, think about the other conversation. I think a meaningful conversation is often a private conversation, and avoid the fishing grandstand story that I talked about before, where I suspect that plaintiff's lawyer talked about fishing with the judge to maybe unfairly bond with that judge or to unfairly alienate a female lawyer who may not have been a fishing sports person. And so I'm going to call that sort of some grandstanding, and that's to be avoided. It's hard to get around because we all want to impress people, we all want to connect with people, especially judges, but we have to avoid that and think about connecting with others from a Dale Carnegie point of view. So careful connection is a good way to reduce bias. Let's talk about bias in action, subtle and unsubtle. In general, I think things have gotten better. We have a long ways to go. I go back to the days when people would smoke in their office in a law firm. And if you were a young associate talking to a partner, he had his ashtray there, and he's smoking, unconsciously blowing smoke in your face, stinking up your clothes, you just had to take it. So overall, our office environment has gotten better, and that includes reducing unlawful or inappropriate bias. Bias in action. In a deposition, someone may ask a female for a copy of the transcript. That presumes that the female is the court reporter. The court reporter, the female may not be the court reporter, maybe be something else. So aren't we sort of projecting a stereotype that all court reporters are female? Now here's one of my favorite bias in action examples that I read about. I've never seen it, but I suspect it happens. And what's interesting is that bias gets down to this level of detail. In an intellectual property firm, it's considered improper bias to not invite the patent writers, but instead inviting the patent litigators on a theory that the patent litigators have better personalities because they're litigators. They take depositions, they talk, versus the patent prosecutors or registered patent attorneys, as I'm part of that group, don't have personalities and wouldn't be fun at a party. Now, when I read this, I thought, well, maybe that is a correct bias, because most guys who write patent applications aren't very affable. And but are they a protected class? I don't think so. Us patent lawyers, patent litigators, patent writers really don't drill down to a protected class. But yet, in some of the literature on this subject, it is considered an improper condition of employment to just not invite the patent writers, but instead invite the patent litigators. So I didn't make this up. I read it myself. So the issue here is, yes, bias may drill down to, I think, this ridiculous level. Other hand, if you're in a large law firm and you write patents all day and you're in a room by yourself, it would be hurtful to not be invited to the parties when you see your colleagues being invited. So it's a first world problem, but it's a real problem. So it's something we need to be mindful of, and until now I was never mindful of it. That in some law firms, the patent writers, they don't get invited to the party. So we've got to stop that, invite everybody to the party. The other thing that I mentioned earlier that may be a little controversial on my part, in some large law firms, various associates are encouraged to serve on diversity committees unless they lose billable hours. Now, the selection of those attorneys for the diversity committees, I'm guessing, is based upon one of the protected classes, and it's done to bolster the reputation of the firm, arguably to increase diversity within the firm. But are the members of that committee, don't they lose billable hours? And is that going to hurt them in the long run as lawyers, or their potential to make partner at that firm, or with their ability to garner their own clients? I'm going to leave that alone because I don't want to get in trouble here for being inappropriate, but it's just something that I think is worth thinking about. The other issue to reduce bias is just a general theorem that I think we can all enjoy. Actually comes from one of my favorite jury instructions. It's to withhold judgment until you've considered all of the facts. Also in the jury instructions, it talks about not to discuss the matter with each other until you've heard all of the evidence. So when I get lost in litigation, I look at the jury instructions. And I think in life, a lot of good things can be learned from looking at the jury instructions. So another college professor once told me that there are very few emergencies in the legal field. Thus, here's my part, we have time to study and think before making decisions. So we have time to think and study before making decisions in our lives, I think, and in the law-related field, and we can withhold judgment and consciously avoid a bias or an unlawful discrimination. So in a way, we have an advantage being lawyers. We have time to think and consider. We don't have emergencies such as you would if you were an endodontist or emergency room physician. The other thing I want to talk about is that whatever we're doing, with respect to this great program in California to eliminate, or my theory, reduce bias. It isn't working. We've got big problems. I don't have to go into that. So I would suggest that we question everything and that you do your own study and you think about the big picture or other points of view, because something has to change. So some of the questions I present is, does the mere study or rote following of state bar rules address the larger issues? In general, the reasons for our bias problems have been a taboo subject, thus there is ample room for your own thoughts and writings. And has bias reduced over the past 5 years? Personally, I don't know. But it'd be interesting to take a survey and figure that out. And also, if you had a spring failure in a mechanical arm, would you hesitate to investigate? No, you grab that arm, you take it apart, you figure it out, and you wouldn't worry about any sort of taboos or other problems in that regard. I wish I could do more on this subject in an hour. Hopefully I've raised some issues for you to think about, to be mindful of. Hopefully you've thought about lawful discrimination, unlawful discrimination, proper bias, improper bias, group theory, how groups are formed, and I look forward to your comments. In this last slide here, you see my contact information, and my website is www.nielsenpatents.com, and I appreciate your attention and thought in this matter, and hope that this just opens your thoughts and opens the continuing dialogue. Thank you.
CCE. For over 20 years, the Center for Continuing Education has been a State Bar of California MCLE-approved provider. CCE programs have long been recognized for their timely, informative, and practical content and the unmatched expertise of their speakers. For information on this or any CCE MCLE program, visit www.cce-mcle.com or email mcle@msn.com. We welcome your questions, comments, and participation.